children who will be at a lifelong disadvantage through no fault of their own. Second, it will ensure that the reoffense or recidivism rate of persons released from Wisconsin prisons will increase because these persons will be given no opportunity to turn away from criminal activity. And third, it will unnecessarily drain state resources to fund a growing corrections department in an era in which the national crime rate continues to decrease because of effective evidence-based policing and reentry programs. Some policies rise above partisanship and political agendas and go to a people's character. Winston Churchill, the same man who said there's no such thing as a good tax, also said that you can measure the civilization of a society based on the way it treats its prisoners. A person who wants to see Wisconsin taxpayer dollars spent wisely cannot vote for this bill. A person who wants to increase public safety cannot vote for this bill. And most of all, a person who believes in the Christian principle of redemption can't vote for this bill. Thank you.
Thank you, Ms. Shoptaw. Any questions by the committee? Yes, Senator Grothman.
Thank you.
Yes, Senator.
As was mentioned in the original testimony, there is vagueness in the law, and people do not know if the government feels they are breaking the law until they wind up before an administrative law judge. Now, I realize that many people here today are not have any sympathy at all for businessmen, but does it bother you that we have a law out there that you have no idea whether you are breaking it until you get before a judge? Nobody can tell until it's so vague until you get before to give an administrative law judge who will make a determination that may vary considerably from another administrative law judge. Does that bother you at all?
I guess, I guess there are two different ways to answer that question. The first is that only large employers would have, the scenario was framed earlier as 9 decisions made with the same reasoning, and on the 10th time, that employer did encounter some resistance. That wouldn't be a small employer. I mean, based on the numbers we've heard today, there's only a handful of these cases in the state overall. So spread among all employers, that's a bigger business that would have to deal with that. The second way I would answer that is that when businesses have a way of reasoning and they talk to their attorneys who they pay very well to do this work, they should be able, with all that legal expertise, to formulate some sort of test that they can codify into policy that would prevent this type of discrimination. It's sort of naive to say, with all due respect, at the very last moment, they just realize this is discriminatory. There's usually a paradigm that they would be able to follow with all that legal expertise that would allow them to know that's where they're going.
I'll give you one more question.
Sure.
We didn't have the information before us today, but eventually this committee will get the information. And when it's available, I'm sure they will find that over 80% of the people who file a claim based on conviction record will not even make it to the probable cause stage, much less be shown. Does it bother you? I mean, I'm sure it would bother you if 80% of a given class of people were arrested for crimes they didn't commit, and then later on they could prove that they were innocent. Does it bother you that so many frivolous or spurious claims are filed against Wisconsin business that does that bother you at all that businessmen have to go through that, being unjustly accused of breaking the law?
Well, of course, in principle, frivolous claims are offensive and should be to anyone. I guess the answer, though, is in the question, sir, because what you're really saying is that these cases aren't getting passed. They aren't being given to the point of where a court would even take over. So the legal expenses in the administrative process, because as you're saying, if it is true that 80% of them won't make it past that point, there's really very little legal expense incurred. So if they are truly frivolous, they won't really carry an unnecessary financial burden for the employer.
Okay.
Any other questions for the committee? Hearing none, thank you for your testimony.